my lords and my lady, doctor, for you to imagine the circumstances that would be if the orders are not confirmed by this honorable court, then, my lords and my lady, you must, and I say this with tremendous respect, reflect on the assumption of the Office of the President Act in order for this honorable court to be alive to the prejudices or the prejudice that the petitioner and the Honorable Deputy President Rigathi Gachagua will face if the orders sought are not confirmed. My lords and my lady, we make the submission that to disallow our application will lead to a wastage of public resources, which this court is joined under Article 201D. My lord, this court is empowered or given the obligation under Article 201D of the Constitution to ensure the prudent and responsible way of the use of public resources. So that, my lady and my lords, the denial of the reliefs that we seek will automatically prompt the swearing in of the person of Professor Kithure Kindiki to assume the office of the Deputy President Rigathi Gachagua. My lady and my lords, pursuant to Section 12 of the assumption within the capital city of the Republic of Kenya, which is in Nairobi, and secondly, on that date when we are supposed to have the swearing in of the Deputy President, must be a public holiday. My lady and my lords, while being treated to a public holiday might not seem to be a bad thing, as it will give the court and councils an opportunity to rest, it's a bad thing for one that, firstly, Kenyans who live from hand to mouth will have to take a rest. Secondly, at a time when this honorable court is expected to be doing its business, this honorable court will be forced, my lord, to retire and perhaps to add onto the backlog of cases that we face in the Republic of Kenya. So that, my ladies, my lords, as I conclude my very humble submissions, so that I can pave the floor to my senior, is, my lords, you have an opportunity of arresting a situation that will lead to the use of public resources in a public ceremony that may, in the fullness of time, end up be declared as unconstitutional for the very grounds that we will be persuading you when we come to making arguments in support of the petition that lies before court. My lords, that should be all from me. I will pave the floor to my colleague Wanjiku.
Thank you.
Thank you. For the ninth petitioner. Thank you.
My lord, may I just for housekeeping, my lord. My lord, is it possible that at least the court is told who appears for who? Because we may have, I do not know how many advocates are supporting. We may sit here to the end of time because each person is taking 5 minutes, and my concern is that the advocates who are appearing for the same client taking 5 minutes each, and then we do not know what we're dealing with, my lord.
You appear for which party?
For the ninth respondent, for the ninth petitioner, my lord and my lady.
The same person?
Yes.
You had 5 minutes to share between the two of you. Mr. Wanjiku, Wamboi has taken more than that.
Sorry.
I don't know, should I go? Because I'm for the second petitioner.
Yes.
My name is Kimoto Teresia Wanjiru Makazi, Tess Kimoto and Company Advocates from Kerugoya. And on behalf of the second petitioner, we wish to say that we support the application for conservatory order to remain in force. And the reason why we are saying so is that if you look at our petition, the prayers that we are seeking...
Sorry, my lord, with your permission, my lord, with your permission, I'm sorry, because Ms. Kimodo was submitting, and it was our understanding that for the ninth petitioner, because she is not representing the ninth petitioner, it was our understanding that the minutes that were allocated to us, initially, Mr. Shadrach Wamboya has taken, and we were to compress the same so that all parties appearing, because we are 4 of us, were to iron out those issues and submit, because it's only submitted on one point. So that before she submits, we're requesting kindly for accommodation so that we can air 1 or 2 issues that were left out by Shadrach. Because I was to do a minute, and Mr. Omari was to do another minute as we conclude for the 9th petitioner. We are sorry about that, so that when she takes up, she'll take it up from a standpoint of...
Does it also not bother you that most of the points or the principles you are putting forth have already been put forth even more eloquently and recorded?
My lord, that much we agree, but there are 1 or 2 issues that were left out. That is why we wanted to seek for your permission so that we can air all those that...
I think we still believe in the old doctrine that a council can stand up and say that I adopt wholly the submissions of a council who has gone before them, because I think these arguments have been put very eloquently and we have recorded them.
Very well, if those be the directions, my lord...
But I'll give you 2 minutes.
2 minutes.
After Ms. Kimoto has finished.
We are most obliged. We'll share 1 minute each with Mr. Mari. Thank you.
Yes, sir.
People are yet to come, including the respondents. I hope you take note of that. There's no need for repetition, absolutely none.
Yes, sir. The reason why we are in support of the conservatory orders remaining in force is that when Justice Richard Mwongo was issuing these orders before Kerugoya Law Courts, he had in mind petition E013 and petition E014. So he knew very well what he was doing, because we appeared before him several times and we tried to stop the impeachment proceedings. However, it was not possible, and he consolidated the files. Therefore, if you look at our petition E013, what we are asking for is an apology by the Deputy President of Kenya, Honorable Rigathi Gachagua. So if these conservatory orders are lifted, what are we going to do? Are we not engaging in an academic exercise where our petition has been consolidated, but we are not being given a right to fair hearing, so that the court can understand why we need this apology? And this petition was filed first. It was filed on the 25th September, before the impeachment and after the impeachment. So we are praying that we be given a right to fair hearing. We be heard first. We have nothing against Professor Kindiki. However, once he assumes office, he will now become a deputy president, and therefore we do not need an apology from Kindiki. We need an apology from Rigathi Gachagua. And we need an apology from him when he's at his official residence. No. They will have, no, allow me to.
My lord, may I just interfere? The petition by Kimodo and Company required the deputy president, then, now impeached, to apologize to the National Intelligence Service, NIS, completely overtaken by events. I don't even know why she's here.
No, that is uncalled for, and I hope the bench will protect me.
I think Ms. Kimoto is rightly before the court.
Yes, thank you. Thank you, Judge, for protecting me, because I almost quoted the paragraph 110 of the disposition of this court where you assured us that we are going to have a fair hearing. So therefore, thank you, Justice Charo. So what I'm saying is that, yes, so what I am saying is that we need an apology from the Honorable Rigathi Gachagua, him being the Deputy President of Kenya. So what we are saying is that we want him, at least we are going to support even the issues of how he was impeached, so that we can get to the bottom of this. And we still have a chance, because he has not left office. And if he has not left office, then we have a chance to be heard in our petition, E013. So allow us to be heard, so that after we are heard, the court can decide if our petition has merit or not. And that's why we are in support of this. And we do not want a kienyeji apology. Our apology is very clear from our pleadings, because these utterances he made when he was in office, and they carried weight. Why we are insisting is that the NIS team, and especially my client who is affiliated to the NIS, he was affected. In fact, where he stays in Kirinyaga, he cannot stay anymore because of those utterances. No, these issues are in our petition. The respondents have not responded. In fact, our petition is unopposed. So therefore, we are insisting, if at the interim stage, the conservatory orders are lifted, what it means is that we will not have a chance to get what we are praying for in the final stage. So it will be in our view, we will have been overtaken by events at that particular moment. Therefore, when we remove this conservatory order, it only means that we'll have a final order in the interim, because now there will be a new deputy president, and we sued Honorable Rigathi Gachagua when he was the sitting deputy president, as a deputy president, not as Honorable Rigathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014, on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, just 1 minute. Again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you're overtaken by events, just like some councils were trying to say. That's all. Thank you.
Thank you. Your Lordship, for the third petitioner.
Sorry, my Lord, I was